listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello and welcome to another episode of Driving Law. I'm Kyla Lee at Acumen Law, and with me my co-host, Paul Doroshenko.
Hello.
And I'm sorry, we're recording the podcast this week on my computer, which I normally use to refer to the things that we're going to talk about. So now I have to use my phone, and that makes it look like I'm texting in the podcast, and I'm not.
You're not texting, no. You're just getting case names.
Case law. Yeah, so it's been a bit of an interesting week for driving law. The first thing I want to talk about is this case out of the Nunavut Court of Appeal.
Oh,
where
tell me about that.
Yes, I did.
Okay.
A couple days ago.
I don't remember.
Nothing ever driving law related really seems to happen in Nunavut, but there was a case where a number of Inuit sustenance hunters were arrested and charged with impaired driving, and they challenged constitutionally the mandatory minimum sentence of a 1-year driving prohibition, arguing that it constituted cruel and unusual punishment because effectively there ain't no public transportation in Nunavut, and especially not public transportation that's going to take you to your traditional hunting grounds.
And a snowmobile is a conveyance.
Conveyance, yep.
In Canadian law.
Yep. So you so they would end up essentially not being able to practice their traditional culture. That is far and above a what would be a proportionate sentence for a person convicted of impaired driving. And the Crown, surprisingly, did not dispute that the sentence represented cruel and unusual punishment. They conceded it.
Those are strange instructions that they had. They obviously had to go up for that, right? It was not just a decision made locally. I'm sure it was a decision that was made with some instruction from the Department of Justice, probably in Ottawa, bearing in mind that this was in Nunavut.
I would guess that the instruction was better to concede it on this case in this jurisdiction that will probably not have far-reaching implications across the rest of Canada because of the specifics of the nature of, these particular individuals.
I can't speculate about why they made the decision, but they conceded it there. And I think they basically probably conceded it because to do otherwise would have been foolish.
And they also did not seek to justify the restriction under Section 1 of the Charter as, demonstrably justified in a free and democratic society. So they basically said, yes, this is unconstitutional. Yeah. And the judge said, that's nice. But I don't find any evidence that it's unconstitutional, and I don't think that even though the Crown is literally coming to court and saying, yes, it's unconstitutional, and no, we can't justify it, we did bad law, the judge was like, they haven't met their burden.
Still haven't called the evidence to persuade the court.
Yep.
Which is strange. It's a strange decision in that respect.
Strange.
I mean, you can... how... So many things you have to call evidence on, and you're wondering, what do I need to call evidence on, and what it just sort of makes sense, and what should I just be able to stand there and explain, and everybody will know it because everybody has this common knowledge together. And why shouldn't just the explanation of counsel be sufficient to make that out? And then some judges seem to be fine with it when you go in to explain something, and then sometimes you have to call evidence on every little point.
Yeah. Anyway, so Nunavut Court of Appeal basically said, no, we'll hear this. So all it was so far is a leave decision, the Nunavut Court of Appeal granting leave. But it will be very interesting because conceding it and having the decision at a trial level in a remote court versus having an appellate level in a situation where a judge, fumbled the ball could make things much different. And with the record being what it is, the Crown conceding it, it's hard for them to now turn around and seek to justify it.
For sure. What is the Nunavut Court of Appeal? Is it like the Ontario Court of Appeal, or is it like two people from Saskatchewan and two people like...
Oh, I thought it was their own Court of Appeal. I thought they had their own.
I would be surprised, bearing in mind the population there. I don't think they would have a Court of Appeal. I would think it would be the same as going to the BC Court of Appeal out of one of the territories, one of the Yukon, or...
I haven't got the answer for you. Anyway, I want to move on to this other case because we got a lot to talk about today. This case is called Buford. And this is a case, it's actually had a little bit of media attention in BC.
Released this week.
The time that the incident happened, because it was a pretty serious accident involving a construction site in Nanaimo. Miss Buford drove her vehicle towards the construction site on the highway at a high rate of speed, rear-ended another vehicle that then caused that vehicle to crash and pinned a guy, and he died. One of the construction
One
workers.
construction worker died, another was injured.
Bodily harm to the flagger. So pretty serious, and the types of circumstances that are considered more aggravating because of the vulnerability of roadside construction workers. And so she was charged with a number of offenses, including impaired driving causing bodily harm and impaired driving causing death.
Yeah.
And what happened when the officer showed up at the scene is he starts dealing with Miss Buford. She's acting kind of weird.
He's still in her vehicle. She's in a Honda Fit.
Yeah.
And she goes to have a sip of water and he stops her.
Yeah. And he tells her she's detained for impaired investigation, basically.
Yeah, more or less.
Yeah. And then from there, he ends up forming his suspicion that she has alcohol in her body.
She makes an admission of having a glass of wine an hour earlier. There's no speech, no odor of
3
liquor,
glasses total.
and no odor of liquor.
Yeah.
And this all happens at 12:04.
Yeah. And then he waits.
Yeah, he radios for another officer there, a corporal, to bring his cruiser closer because he's had to walk a long distance to get to the point where the collision was, because obviously there's a scene at the roadside, and bring his cruiser closer so he's got an approved screening device there with him to be able to go through this procedure. And then he makes the demand, and I think it's about 12 minutes or 14 minutes, something like that, after the time that he's got this admission of consumption, that he ultimately makes the demand. And this is after taking her back to his cruiser, after his cruiser's been brought there, doing a cursory search of her, lodging her in the back of the cruiser. Then he's got the ASD, makes the demand, takes the test, and she blows fail.
Then he arrests her. There's some discussion about the right to counsel. She says she wants to talk to a lawyer. He takes her back to the police station. And then at the police station, she, at some point in the intervening time, like between the ASD and when I can't remember when, but at some point she pees herself. She tells the officer.
It's at the roadside.
Yeah. She tells the officer this. He says, "We'll get you a change of clothes at the police station." He doesn't.
That never happens. And she's cold and is asking to go to the bathroom, not offered a blanket or anything like that.
Not permitted to use the bathroom. So, number of issues there.
Then there's video at the detachment that is taken and not retained. They destroy it.
Yes.
Never disclosed.
So yeah, a whole host of issues. Lots of breaches of her charter rights.
Yeah, it's an interesting case. It's an interesting case because it's an admirable job done by the court. It's like a court that understands impaired driving law clearly. We don't always get it in these very clear statements. Ultimately, the initial detention is an unlawful detention. She's not properly informed of why she's detained. Yeah. And he doesn't really have the correct opinion to detain her at that point in any event.
Specifically, the court sort of draws this distinction between an investigative detention, which is a brief detention that's reasonably necessary for the purposes of investigation grounded in a reasonable suspicion of criminal activity, and like a full-on, de facto arrest type detention. And part of the court's concern, and he actually found it was also a Section 7 breach in that it denied fundamental justice, was that the officer didn't specify to her when telling her that she was detained whether she was detained for the offense or detained for investigation. And the court
detained her for impaired operation, I think, which was...
Yeah, but he didn't specify for investigation of impaired.
Don't say for investigation of it.
And so that was found to be a violation of her Section 10A rights, but also her Section 7 rights. And the court said, look, for a person to decide whether they're going to submit to a detention, they need to know, it needs to be clear to them what type of detention the officer is actually trying to affect.
You're never in a position to make a determination yourself as to whether or not your detention's lawful at the roadside.
Side, I would just do.
Yeah. And so the court is protecting people's right to be free from unlawful detention by making these decisions that say, look, in these circumstances, you would have been entitled to resist. And then later on, let's talk about what the remedy would be.
Yeah.
But the real remedy evolves really from the ASD.
And that's what
Mostly from the ASD.
found this case to be most helpful. Because there's been, as you remember from the early days of impaired driving cases in your career, back in the day, it used to be if the ASD was unlawful, it was just understood that the grounds for everything else disappeared too.
And there's good reasons for that.
Because
your 10B is right to counsel, your right to be notified of your right to counsel, your right to exercise your right to counsel are both suspended in those circumstances. An ASD is illegal and only permissible because it complies with Section 1 of the Charter, so it's already on thin ice. And if you fail to comply with the requirements in a warrantless search, where your only lawful authority arises from the criminal code, and you fail to comply with those requirements of the criminal code, judges would just, when I started practicing, would just say, okay, ASD, it's unlawful. That's it. We're not even, everything else is fruit of the poison tree. We're not going to really consider, we don't have to consider the 24-2 analysis because we know that the arrest flows from the ASD.
Yeah.
And everything fell away, but started to drift from that
into the 24-2 analysis on ASD. Should I exclude the ASD result from evidence and thereby preclude the officer from relying on it, which is then gets us to a second 24-2 analysis on whether or not to exclude the results of the breath samples. Like, it's a little bit silly. It turns what should be one very simple analysis into multiple charter hearings.
Yes.
But this case resolves that. And paragraph 110, I think, is beautifully written. It says, I conclude, actually, sorry, I want to back up. There's a case from the Supreme Court of Canada a couple of years ago called Zacharias. And now I'm going to back up further than Zacharias and talk about rilling. And you're like, God damn it. For those in the impaired driving world,
covered my face for a second. That's interesting.
Yeah. For those in the impaired driving world, rilling was this case that dealt with this issue of reasonable grounds and whether, if the officer didn't have reasonable grounds for the breath demand, did that mean that the samples were out? Basically, there was no statutory compliance, or was it a charter issue? And the law went like this for a long time. And then there was a case called Alex, maybe a decade ago. And in Alex, the Supreme Court of Canada finally resolved it and said, no. That's the whole point of the charter. If it were just that the statutory preconditions had to be met and nothing more, then the Parliament would have written it that way. But they didn't write it that way. Your remedy lies in a Section 8 breach. And so I've been saying since Alex, look, the implication in Alex is that if the breath demand doesn't comply, if there's no reasonable grounds for the demand, then the samples are out. That's the implication from the Supreme Court of Canada.
That was my interpretation long before.
But out under the charter, not out under like common law. And
no, but I mean, I was making that argument before.
I just wanted to clarify what I said for our listeners.
Okay.
You understood me, but they might not have.
I just thought it wasn't, you've got two different ways that you could go, but either way, it's not. Yeah.
And then the Supreme Court of Canada a few years ago released a case called Zacharias. And Zacharias is a case about what happens when you have a two-stage regime for obtaining evidence. And if the first stage isn't complied with, can you still nevertheless rely on unlawfully obtained evidence as grounds for a later authorization? And it comes from the search warrant world, where in search warrants, if you violate the charter, the rule has always been that any evidence that is obtained in violation from the charter gets removed from the search warrant authorization. And the Crown, for obvious reasons, didn't like that. They wanted to be like, no, some of it can go in, and we should have an analysis about whether it should go in. Supreme Court of Canada, Zacharias said, no. If unlawfully obtained evidence exists, it cannot form the basis for a later authorization, because then you're just allowing the police to breach rights on the hopes that, the later authorization is going to stand. It encourages mischief.
It does.
Okay, so that is the context. So since Zacharias, I have been saying to the Crown, anytime there's a bad ASD, Zacharias says that this ASD is out. The ASD is just gone from consideration. And I've even had judges push back on this in like pretrial conferences where they've said, I don't know that that's what Zacharias says. And I said, well, no, Zacharias is not about ASDs, but it's about a two-stage analysis. And I'm like, I don't know, Miss Lee. I'm not sure. Well, you can be sure now.
That was really just confirming what we thought before and what we had how we had considered it prior to the end of Stillman. Anyway.
So here's Justice Thompson of the BC Supreme Court, binding on all our BC provincial court judges, saying, I conclude that the ASD result obtained after a non-compliant demand constituting an unlawful search and seizure conducted in the course of an arbitrary detention must be disregarded when considering if the police had reasonable grounds to make the 320.28 breathalyzer demand. This approach is logically consistent with the analyses of the majority of judges in Zacharias, who held that the Crown cannot rely on the product of an unreasonable search in an assessment of whether there were grounds for the arrest. I cannot think of any reason why the same principle would not have application to the two-stage search process established by sections 320.27 and 320.28. The raison d'etre of the first stage roadside ASD search is to determine if more conclusive testing is warranted in the form of the second stage breathalyzer search. If the first stage was an unreasonable search, surely it cannot be relied on as the grounds for the second stage search. Oh yeah, mic drop. Anyway, important case for that reason. That's probably the most important principle that comes out of it. But of course, there's so many other breaches found. Like, you can't let someone sit in their pee.
Yeah, there's other breaches found. The right to counsel, there was no breach found there, which was somewhat interesting to me because of the way that it was set up. But of course, the judge chooses what facts they're going to tell you in their decision, and didn't find facts that would lead to a 10B violation in the implementation of the calls to legal aid and so forth. But it's also said it was on the line because there had been like 30 minutes where the police didn't do anything after they made the initial call to legal aid. Bearing in mind the fact that this woman is basically sitting there in wet pants, and cold. But the judge said no, it was okay. But it's an interesting, very clear case, and if you're interested in impaired driving law, it's certainly worth reading. The sad thing is the mistakes that were made and how we ended up in this situation. Because really, this will lead to an acquittal. It's not the end of it, but it's
she got acquitted of the impaired.
Yeah.
And the over 80, she was convicted of the dangerous. The driving was real bad.
Well, one way or another, I don't know what driving took place before this, but one way or another, she struck somebody, killed them, and then rear-ended a truck at the same time. So, like a truck with big lights on it.
Drove past all the signs of a construction site, so stopped vehicles.
So dangerous driving.
At high speeds. Had warnings, didn't.
But, she blew 120, 130, or 130, 120. And obviously alcohol was there, but it wasn't something that could be considered. It wasn't admissible evidence. It wasn't, nothing proven about that reliability of it. It's just that was part of the context that we were given during the course of that voir dire decision. But, backing up, going 2 decades back, a little girl, Alexa Midlar, was killed. And as a result, we ended up with the immediate roadside prohibition scheme in BC. And with the immediate roadside prohibition scheme in BC, police officers conduct investigations, and often the investigations have all sorts of horrible problems in them. But they submit their report to the superintendent of motor vehicles. They are never cross-examined. They are never called into the supervisor's office when they've done something wrong. Most of the time, the superintendent of motor vehicles will go through all sorts of machinations to accept the police evidence and reject the evidence of the applicants, and accept the police evidence in circumstances where you can see charter violations there, and yet they will skip past it, knowing that the individual is not likely to appeal it to BC Supreme Court. If they do, the lawyers for the government will stop any bad ones from going to appeal and send them back for a rehearing.
Yeah.
And the consequent result, and I've said this from the beginning, and here is the manifest example of it, is police officers who are de-skilled, a police officer who delays an ASD demand for a long period of time. There's other things here that the police officer didn't know how to do, didn't do correctly, and there was other things that appeared on the face of it could have been argued too that weren't, because they picked the best things to argue. They were good arguments made by counsel here, but this is the full-on de-skilling. And here you've got someone who is ultimately, you can say, because of the IRP scheme and the police being de-skilled and the superintendent of motor vehicles office complicit in this, because they routinely give the police a pass and the police feel that they've got their back. Here we have a case of a person who otherwise, that evidence may have been properly obtained. And because it wasn't properly obtained, she ends up with an acquittal essentially on the drinking driving aspect of the charge, and in circumstances where she killed somebody.
Yeah.
So for me, it's upsetting to see. This is just that's not a nice "I told you so." It's it frustrates me. It makes me upset. I feel, and I've told you this before, when I borrow a car, I borrow something from somebody, I like to return it in as good or better condition than I borrowed it. And I've always felt that I borrowed the justice system. I'm only doing this for a few decades, and I should return the justice system in the condition that I got it. And I feel that I failed in that.
All right. The auto zoom here has forgotten I exist. There we go. The
Male bias.
discussion you were having, though, about lack of competency and the de-skilling due to the IRP scheme, that discussion is an important transition into our last topic before we get to our ridiculous driver of the week, which is on the public consultation that is taking place now until February 27th. I want to encourage all of our listeners to go provide your input to this. We will put the link in the description for the podcast this week. This public consultation is about the role of non-lawyers, specifically paralegals, designated paralegals that will be managed by the Law Society under the new Legal Professions Act. And as you and I had very accurately predicted, what are they going to let paralegals do in BC? They're saying traffic court, administrative tribunals, provincial offences, and summary conviction offences, which happen to be driving while prohibited, where you could go to jail, lose your license for a year, lose your job, lose your livelihood, lose your home. Impaired driving, where you could lose your license for a year, go to jail, get deported, lose your status in Canada if you're a refugee, go back to the country that that did something bad to you, or you might die. No problem. We let a paralegal deal with that.
So essentially, what they want to do is they want to take people who don't have the skill of driving lawyers, and they want them to be able to take the cases that we've got. So you can say we have a vested interest in this not happening because this is our job, right? This is how we earn our living. But on the other hand, you can look at it and see the world of grief that Kyla and I and other lawyers have caused the government by advancing things courageously, because we're lawyers and we've been able to courageously do it in the past. I don't know how courageous we'll be able to be when the government is now the Law Society, because they can come after us anytime.
They're taking our livelihood.
They're trying to take our livelihood here, I suppose. On the one hand, they've always thought that we are got a good gig going by defending these cases. And that was half the reason for the IRP scheme. They thought, well, people are paying $5,000 to a lawyer on a drunk driving case. They should be paying that $5,000 to us. And I know that discussion took place because I heard it from people who were in the industry.
From FOIs too.
Yes. And so,
remember the one that was like, we didn't actually make as much money as we thought we would. Turns out it's a lot more expensive than we predicted.
Yeah. With the IRS.
And then they blamed the lawyers.
Yeah. And for us correcting the law. They wanted to be able to uphold every IRP. They wanted the police to never be accountable. But the police are not accountable. They've managed on that one. They also de-skilled the police. But they wanted to turn it into a revenue-generating system for the government, and we have been the impediment of that. And now their next step to try and deal with that is to try and take us out of the picture so they can turn it back into a revenue-generating thing by not having lawyers doing it, by having paralegals do it. Yeah. And that's our perspective on it, obviously. I also don't see, there's no hue and cry out there. The people are not, people are not short of representation when it comes to that. There's
family law stuff.
There's
Absolutely.
us, there's Philco's office, there's a couple other offices around that do like driving stuff. It's not,
There's lots of people who do driving stuff exclusively. There's also people who do driving stuff in addition to their regular practices, and it's very affordable. We are very affordable.
and when you go to
Not
court, when you go to court, you're not ending up sitting there watching a trial of a self-represented person on a drive while prohibited or impaired driving or something like that. The self-represented individuals you're watching in court, unfortunately, are in family law cases, often with custody issues, and there.
I think, WCB tribunal, places where there's not a lot of lawyers, where access to justice is hard, where it's the cost of hiring a lawyer outweighs the benefit you might get. Yes.
Residential tenancy.
Well, I don't agree with residential tenancy because evictions.
Yeah.
I think for something other than evictions, like short of eviction, maybe like getting your security deposit back or something like that, damage dispute, that type of thing. But evictions, I think it should be lawyers.
No, but when it's an issue about money, when it's a dispute about like fixing the dishwasher or something like that, like it's, that should be a paralegal. You don't need a lawyer because you can't, the cost all related to it does not justify the having counsel.
Yeah. But, they also they sell you on this myth. And this is when it happens, if it happens, and this is why your voice is needed, because if you have been listening to 430 episodes, this is our 430th episode, 430 episodes of driving law, you probably know by now that this is a really complicated area of the law. And they're going to sell you. The government is going to sell you, and paralegal firms are going to sell you on the myth that this is simple, that you don't need a lawyer, that anybody could handle this. Paralegals are equipped to do it. And it's just not true. If you're a listener of this podcast, you know how complicated it is.
We've also gone through lawyers in our office who couldn't do it. They,
it's not for everyone.
It's not for everybody. They're competent lawyers, they're good, but they weren't lawyers who could do this specific thing. We're just very lucky that we have the group that we have now.
I've definitely had friends who've picked up, they're criminal lawyers or other types of lawyers, and they've picked up the odd file in traffic court or an IRP or something, and they're thinking they're just going to do it as a favor to whoever or whatever.
Do it for a friend.
Yeah, do it for a friend, or do it as a favor to a really good client, and they get in over their heads. And these are trained lawyers, and they get in over their heads in places like traffic court. I've been to traffic
Someone
court.
got in trouble.
I have been to traffic court where lawyers have gone to traffic court thinking it's probably not that hard. I can do my own traffic ticket. And I've had to intervene to help them in the moment like that. It's not as simple as you think.
So the government knows this. They know it's complex. They know that it's not, but they are operating under the assumption that they can persuade enough of the people in the province that it isn't, and therefore, and they're doing this in the in this context here of claiming that there's an access to justice issue. That's always what's held out, and there's these people at the big firms are more than the big corporate firms are happy with that. Why? They the heads of those big corporate firms have a motive too.
Yeah.
They like young lawyers to be easier to hire for less money.
Yeah.
And we're looking at a potential AI hitting the legal profession, which it's going to hit all sorts of different professions. Should lawyers be charging $15 an hour for their work?
The perfect storm, Paul. A paralegal handling your impaired driving case using ChatGPT to figure out the defenses.
And it will happen.
RIP.
Pretty much guaranteed.
Yeah.
So I never understood this, but man, we've faced this over and over for the last 15 years. And even before that, I faced it. Years ago, those ticket people wanted to come to BC. They were prohibited from setting up in BC because there was a court order, and it's still in place, prohibiting them from coming and just using retired police officers acting as paralegals. It wasn't permitted.
That court order will continue to exist unless the government consents to have it.
There's lots of ways it can be undone by legislation.
They have to undo it, is the point. They will have to take steps to undo it.
Probably. But the previous version of the Law Society, when it wasn't run by the government, took the position, and I spoke out about it and talked to them about it when I was speaking out about it, took the position that, look, we protecting the public means having people who are lawyers dealing with these things. And there's lots of, we can explain the particular powers, authority, and role of a lawyer in this we're just assuming that you understand that, but that could be another podcast for another day.
There is also a blog post going up on my website, kylalee.ca, if you want to check it out. But Paul, let's now just get even more depressing. I feel like our podcast is starting on like a good note, the constitutional challenge in Nunavut, and it's just getting increasingly more depressing.
Interesting constitutional challenge in Nunavut.
We are ending on a depressing note.
Well, these are not bright and cheery times.
No. So our ridiculous driver of the week is actually the ridiculous DMV of the week.
So Florida, you don't hear that much about Florida these days anymore. Back when the election was running and Ron DeSantis was out there supporting Donald Trump, you did. But now Ron DeSantis is sort of hiding under the blankets because the Trump regime's poll numbers are down to 0, and a lot of people are realizing that they've been sold something completely different from what they ended up getting. But it hasn't stopped Florida from being not a great place for many reasons.
Yeah. And one of them now is that Florida is now canceling the driver's licenses and requiring people to retake their driving test if they did not take and pass their driving test in English.
So
doesn't matter if it's Spanish, doesn't matter if it's Mandarin, doesn't matter if it's Turkish.
So our ridiculous
indigenous language.
Our ridiculous driver of the week is the state of Florida, not just a Florida man, as it has been many times. It is the state of Florida canceling driver's licenses purely on racism. You think about it. You're Spanish, you speak English, you've been speaking English for racism. Same thing, whatever. It's always hand in hand.
There can be white people that speak Spanish.
I know.
What if you speak French?
That's what I was going to say. I mean, you could be an immigrant from France, and you could have a driving test person who is fluent in French too, and you guys could conduct the test and pass the test in French. And now they're going to cancel it. But really, of course, let's talk about what we know here. It is to go against people who are Spanish speaking. That is what it was intended to do. And it's to try and cancel driver's licenses for people who got their driver's licenses speaking Spanish.
Despite the fact that even though you might not be able to recognize the word stop, although you probably do know that one if you passed your driving test, the stop sign still looks the same. It's that red octagon. It's the same everywhere.
They passed the test. They did the road test, presumably. They passed the test.
So your driving skill has been assessed.
So Florida is making a declaration that if you have a mother tongue other than English, they don't want you there. And your English might be pretty good, and you may have just chosen to do it in Spanish because you had a Spanish assessor there conducting the test with you. And they're going to cancel
your English might be terrible. You might not have all your teeth.
That's true too.
You can't read by choice, and you can pass your driving test.
Yeah, just because you managed to. Yeah, your English might be awful, but you did it in English.
Yeah. Ridiculous. Absolutely ridiculous, but not in the fun, pleasant way.
Yeah, well, it's in the dark timeline way that we're in right now.
We are in the darkest timeline.
Okay, on that happy note.
Well, that's our podcast. If you have a driving law-related issue, you can find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law, and hopefully a less depressing one.